Tonight, the impending legal battle over the anti-gay bill, as sponsors of the bill vow to fight suit seeking to impose an injunction on the parliamentary process to pass it. We tell you why the plaintiffs accuse the Speaker of Parliament of supervising an illegality. We have the latest.
This is Top Story with Evans Mensah.
Top Story is always brought to you by Vodafone. Tonight, a fierce legal battle is set to unfold over the anti-gay bill, currently at an advanced stage in Parliament. Sponsors of the bill are bracing themselves to fight a suit filed at the High Court seeking to impose an injunction on the parliamentary process to pass it. The Speaker of Parliament himself, Aban Bagwing, is being accused of supervising an illegality. After months of controversy, the bill appeared to have received a massive boost, with both sides of the political divide agreeing to recommend its passage. But there is a massive setback tonight that may stop the process going forward. Kojo Brace is with me in the studio with details of this particular suit that has been filed at the High Court. So who is behind this?
Is a private citizen by name Paul Boama Sefa, who's a resident of the Ashanti region.
Okay, yes. Who's in particular? Is he, what do we know?
He's a farmer.
He's a farmer?
Yes.
Okay. So this is a farmer who has decided to take this up. What's his beef with this whole issue? What's his concern?
So the crux of the issue that he's putting forth is the fact that the law enjoins every private member's bill, which is presented to Parliament, to be accompanied by a fiscal analysis report, and this particular one that was sent or that was laid in Parliament didn't have that one, and he avers that with that being part of the bill that was sent, then it nullifies it in the first place. He is accusing he's alleging that the first defendant, who is the Speaker of Parliament, did not do due diligence in ensuring that particular provision of the law was obeyed when that bill was being laid. So he wants the right things to be done. He's again alleging that the Attorney General, who gave his legal advice, really referred the House to that particular provision of the law, which says that every a bill that is to be laid in Parliament should come along with a fiscal analysis report, was not done, and he wanted to remind the House that they have to do that. He's saying in his writ that particular advice was sidestepped, and that did not bode well for this particular bill.
No wonder he's not only suing the Speaker of Parliament, he's suing the Attorney General as well. As you've noted, because the Attorney General had advised that this should be complied with, and he claims he hasn't been, and so both sides should be held accountable for it. So very specific.
In fact, he makes references to Article 102 of the Public Financial Management Act, which says that every when you are presenting a bill to the House, it must, like we said, it must come with that particular financial analysis report. He really cites all of those authorities to back his claims.
Now, let's talk about specifically what is he asking the High Court to do when it comes to this particular bill, members of Parliament, the Speaker himself. What is he asking the court to do?
So he's asking for a declaration that the first defendant, who is the Speaker, has a non-discretionary obligation to ensure that all statutory requirements relating to the presentation and or consideration of the promotion of proper human sexual rights and Ghanaian Family Values Bill 2021 placed before Parliament, including the requirement for the bill to be accompanied by a fiscal impact analysis when it was first laid before Parliament, are complied with. 2, a declaration that the failure of the first defendant to perform this non-discretionary obligation and the failure of the second defendant to insist and ensure that the requirement that the bill be accompanied by a fiscal impact analysis when it was first laid before Parliament was complied with, has rendered all processes in respect of the bill to date invalid and void by reason of illegality. 3, an order restraining the first defendant his deputies, his agent, assigns, and privies from proceeding with any processes related to the bill until the statutory provisions of Section 101 of the Public Financial Management Act 2016 Act 921 are complied with.
In other words, this is the part that is seeking to stop the Speaker,
Yes.
members of Parliament, or anybody else related to this from touching this bill
Exactly.
until this matter is addressed.
Now, for an order directing the first defendant, his deputies, his agent, assigns, and privies to ensure compliance with Section 102 of the Public Financial Management Act 2016, Act 921, before any further steps are taken in respect of the bill. 5. A perpetual injunction restraining the defendant from further breaches of the Public Financial Management Act 2016, Act 921, and any further orders or other reliefs as the court may deem fit.
And considering that the chairman of the committee himself had told us that he's confident that they will pass this bill this year, this could be a potentially major upset that could stop this whole process from going forward. Let's get clarity on, so where are we when it comes to this bill in Parliament? Parliamentary correspondent Kweku Asante is with me. Kweku, where is this bill as we speak?
So just before Parliament went on Easter break at the end of March, the Constitutional Parliamentary and Legal Committee presented its report to Parliament. Indeed, the report actually recommends the approval to the House. And let me quote that relevant portion. It says, the committee accordingly recommends to the House to adopt its report and pass into law the Proper Human Sexual Rights and Ghanaian Family Values Bill 2021, subject to the amendments preferred by the committee. In terms of the significant question that this plaintiff is asking the Supreme Court to deal with, having to do with the financial impact assessments that have been made, the Attorney General had also raised similar concerns, and this is dealt with in the report. It is under observation 7.1. It talks about concerns about impositions on the charge of the consolidated fund, and that has to do with Article 108 of the Constitution, which says Parliament shall not, unless the bill is introduced, proceed upon a bill, including an amendment to a bill that, in the opinion of the person presiding, makes provision for an imposition of a charge on the consolidated fund. The Attorney General raised this concern in his memo to the committee. The committee says, yes, this report will actually impose significant charges on the consolidated fund in contravention to the provisions of Article 108 of the Constitution. However, they say that the Attorney General's concerns having to do with this particular constitutional provision has been dealt with and will reflect in the amendment that he put before the committee. We are not privy to that amendment in terms of what changes will be made to the bill so as not to infringe on Article 108 of the 1992 Constitution. But the committee says they've been able to deal with that concern of the Attorney General, for which reason they are recommending to Parliament to approve and pass this bill into law.
Kweku, thank you very much. Let's speak to one of the sponsors of the bill, the main voice advocating for it publicly, Sam George, MP for Ningo Prampram. Mr. George, thanks for your time here on Top Story. Hello, Mr. George. Okay, we'll get Sam George's attention on the matter and question if indeed they have received a copy of this particular suit, by Parliament to be very specific, and what they plan to do about it. Hello, Mr. George.
Hi, good evening, Evans, and good evening to your listeners.
Thanks for joining us. So, do you concede that the bill as it stands right now is in violation of 10.1 of the Public Financial Management Act 2016 Act 921 has been suggested in this suit?
Absolutely not. Anybody who draws that conclusion doesn't understand the law that they are quoting.
Please explain, because it's clear fiscal impact analysis. He makes the point in the case before the High Court that as it is right now, that document that was recommended and going forward is without that fiscal impact analysis. Do you have that analysis attached?
Well, the PFMA is subsidiary legislation. It's subsidiary to Article 108 AI. And what Article 108 AI says, or AII, says that Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, proceed upon a bill, including an amendment to a bill that, and this is a critical plug in there, in the opinion of the person presiding, not in the opinion of a so-called farmer from the Ashanti region or myself or yourself, in the opinion of the person presiding. That is what the Constitution says. Every other act of Parliament is subsidiary to the Constitution. And so, without prejudice to the case that has been filed, again, I like I said, without prejudice to the case, think that this case is dead on arrival. It would not even be entertained by the courts, because don't forget, Parliament is an independent arm of government. We are not under the direction or instruction of the executive or the judiciary. Parliament, the Speaker or members of Parliament do not issue directives to the judiciary or to judges of the High Court or Supreme Court. We respect their jurisdiction when a matter is sub judice. When the matter is before Parliament, the judiciary will not interfere in giving a direction to Parliament. We're not under the direction of the judiciary. Neither are we under the direction of the executive. So that's why I hold a humble and respected position that the courts, the respected courts of our land, will throw this case out without even hearing it. Because you can't ask the courts to restrain Parliament from carrying its own function. I mean, that's wishful thinking.
And from Kweku Asante reads the committee's report, and there's a part of it that he reads that talks about the constitutional provision, which is quite separate from what we're talking about, but related, that once a bill imposes a certain financial cost on the state, it poses a clear challenge there if it's a bill that is a private member's bill. And in that particular report, it suggested that this will be addressed going forward. Has that been addressed? Has that been dealt with?
Well, what the committee's report that I have cited and that was laid before the House doesn't say what you're saying. It's the Attorney General's opinion on the bill which was dated October 2021. That says that. Now, October 2022, that says that the Attorney General's opinion to Parliament dated October 2022, the one that makes that allusion. Now, the Attorney General was written to in October 2021 when the original bill was laid before the House for his opinion. That bill has gone through all the clause-by-clause consideration at the committee. The bill in its current form and shape has come with amendments that have taken into consideration the opinion that the Attorney General espoused on the bill in its shape in October 2021. So when in February of 2023, the committee entertained the Attorney General to present his opinion, and the Attorney General was brought up to speed on the current form and shape of the bill, the Attorney General was confident that the bill in its current shape and form does not impose a charge. And that's why the Attorney General explicitly stated in that meeting that he is all for the bill in its current shape and form. And in fact, I asked him a direct question. I said, Honorable Godfrey Dame, can I say to the media that you've given us a clean bill of health? And the chairman said, oh, don't answer that question. And he said, no. He told the chairman he would answer. He said, Honorable Sam George, tell the Ghanaian people through the media that I, Godfrey Dame, support the bill in its current shape and form. And that's why the committee's report has come without any objections from the Attorney General.
Now, if you look at this particular rate that has been filed, considering where you are, and I made a point earlier, the chair himself has said that there's consensus. That's why the committee recommended passage and going forward. This is a farmer who believes something had gone wrong in terms of following the process. He cites a particular provision to back that point. The court will have to make a decision nonetheless. The speaker himself is been cited there as supervising over an illegality. I know you've said that the Constitution, it's on the side of the speaker because it is really in his opinion. But the court will have to make a decision, is it not, that if the Public Financial Management Act indeed has been breached, if it's substantial enough to place an injunction on the process. He's asking for that as well.
With the greatest of respect, I mean, the farmer is entitled to his opinion. I would take the farmer's opinion on irrigation and crop cultivation and cross pollination of plants, and not on an interpretation of Article 108(1) of the Constitution.
As far as the process is concerned going forward, this is just possibly, many will say, and we know the power of the gay lobby. Many look at this and say, we told you the process will not be as smooth sailing as you had anticipated, and there will be bumps in the road. This is first of many. The courts have a decision to make. You anticipate that we may see more, or you see a clear path towards passage?
Well, we're not kidding ourselves, and we're not playing the ostrich with our head buried in the sand. We are very awake to the attempts to filibuster the bill from its inception, and we expect to see a flurry of cases go to the court. But as far as we, the sponsors, are concerned, we are unperturbed by the shenanigans of persons who are interested in having all kinds of despicable acts of sexual engagement and wanting to shove down that our throats as an acceptable way of life. They should continue in their ignominious acts in the comfort of their bedroom and not wish to make it our public discourse. We as sponsors and as Parliament, I am confident in the resolute nature of the Speaker that when Parliament resumes at the end of this month, we will proceed with this bill because no one will stand in the way. And I repeat, no one will stand in the way of the sovereign Parliament of the Republic of Ghana from discharging its duties. And I'm confident that this bill will be passed by Parliament before the end of the next meeting of Parliament. That is a pledge I'm committed to. And that's a pledge I know my co-sponsors and I know the Speaker shares. No one will stand in our way. We're a sovereign Parliament. We'll proceed with our business.
Sam George, thank you very much. Sam George is a member of Parliament for Nego Pram. He is a leading voice when it comes to the sponsors who had pushed forth this bill, which is now almost at the stage where the plenary will consider it. And as both sides have said, there appears to be some consensus on this matter. But for this setback we're discussing tonight, which the High Court will have to take a decision on, let's bring in a man who once was in leadership when it comes to the Constitutional Legal Affairs Committee in Parliament. They've handled several bills such as this in the past. He is no more in the House, but he comes with a wealth of expertise and experience in this area. Inusa Fuseni used to be the ranking on the Constitutional Legal Affairs Committee in Parliament and joins us on the line right now. Mr. Fuseni, I bet you've seen this particular suit that has been filed. Do you agree with the plaintiff that the bill as it is right now, Sam George does not disagree, that it doesn't have the financial impact analysis, but he says that is not needed because the Constitution is supreme. But do you agree that the bill may be in violation, particularly of the Public Financial Management Act?
Evans, thank you for having me. I think that Section 100 of the Financial Management Act is quite clear. The Section 100 of the Financial Management Act requires that any legislation that is to be submitted before Parliament or any proposal that is to be submitted before Parliament must be accompanied by a fiscal impact analysis report on the expenditure and revenue of the state. And that law was passed in 2016. Now, Section 102 requires that the financial impact assessment must be submitted in accordance with the regulations. I have since looked at the regulations. The Minister of Finance has not made provision in the regulations on how the financial impact assessment is to be carried out, who does that, and that's the first hurdle the plaintiff in this matter will have to cross. I see that he has sued the Speaker and the Attorney General. The question is whether it is the Attorney General or the Speaker who does or conducts the financial impact assessment on bills to be submitted before Parliament.
Is it your conclusion then that on the face of the Financial Public Management Act requirements, the bill, to the extent that it lacks this fiscal impact analysis, is in violation?
Well, I've been in Parliament long enough to know that the bills that we have passed over the years have not been accompanied by any financial impact assessment.
So this will not be the first.
This will not be the first. I mean, even the almighty Right to Information Act was not accompanied by a financial impact assessment.
Except that those were not private members' bills.
No, the law says any legislation. It doesn't say private members' bill. It says any legislation. So whether it's a public legislation or a private legislation.
So do I hear you say that if this really and the court now has been filed, there's a high likelihood if the court is interpreting this strictly based on the dictates in the Public Financial Management Act, it may be shut down?
Yeah, what I'm trying to say is that the court will have to answer to the issue whether the Speaker and the Attorney General are the proper persons to sue in this regard.
But who else? I mean, the Speaker is the embodiment of Parliament.
The Speaker receives bills in Parliament, whether they are accompanied by financial management assessment, financial impact assessment or not. He receives the bills, and when they are laid, and the Financial Management Act makes the Minister of Finance the minister in charge of the activities that require any assessment on the impact of bills on the revenue and expenditure of the state.
So, but because it's Parliament that is considering the bill, isn't it just right to sue the Speaker? Because he really wants to stop the Speaker from superintending over what he believes will be illegality going forward.
That's the question I'm trying to answer. And that's whether or not he has the capacity, whether he's properly placed to prevent the Speaker from doing his work as Speaker.
Pretty interesting there. You expect, now that the Speaker has been sued, another question that comes in: who represents the Speaker?
So who represents the Speaker? That's a big question, and so it will be Parliament, not so.
Yes.
So Parliament will have to, the legal department of Parliament will have to represent the Speaker.
Pretty interesting indeed. Thank you very much, Mr. Hussein, there with his thoughts on this. If you're just joining us tonight, there is a massive setback in the offing, but as you heard Sam George indicate already, the sponsors of the anti-gay bill are bracing themselves for a significant legal battle, although they remain confident that they will get the courts to take their side in the matter. The allegation is that bill is currently in violation of law and the Speaker is superintending over an illegality. Well, other advocates of this particular bill are not just looking at the legal dimensions to it. They are reading more into this. Adam Senanu is with the Advocates for Christ Ghana and joins us on the line. Hello, Adam.
Hi, Evans.
Great to have you.
Thank you.
You suggest that there's more to this than simply a suit filed by a farmer at the High Court.
Well, when you have 93% of your population saying this is something they all stand against, and somebody decides to file a suit, evidently he's going against the grain, and it's obviously intentional. I mean, it cannot just be because there's no financial analysis attached. Indeed, anyone who's followed the discussions in Parliament know that the financial angle is one of the key things that has been dealt with because it's a private member's bill, and it is there's clarity that PMB should not bring costs onto the state, and so that's one of the key things that they have ensured that they have addressed through the processes. So you can't but conclude that this is intentional to try and slow down progress.
Well, I mean, but we are a country of law and order. Somebody believes that the law is this bill is in violation of law. It is just right to test it in court.
Well, yes, we'll give them their day in court. I mean, we are Democrats. We accept such challenges, bearing in mind that Parliament is master of its own procedures, and so we wait to see how far that will go. But trust me, democracy is about what the majority believe is right. That's what a democracy is, and that's where we find ourselves. So democracy will prevail at the end of the day.
You're right talking about democracy, and the rule of law is a significant part of that whole democracy, right? I mean, so this is fair game to try and test it.
Oh, yes, I said that already, that we respect that right. So they have their right in court. I mentioned that a few seconds ago. So there's no problem with that. It just slows down progress. But at the end of the day, democracy is about what the majority believe is good for the state. And so that's what we are doing at this point.
Well, I know you were part of the process of trying to review the bill, and you made presentations to Parliament. We've heard from the Parliament, and the recommendations have gone through now, asking that Parliament considers it. The challenges have been addressed, and Sam George says he's very confident that this Parliament will definitely pass this before it is dissolved. You share in that confidence?
Well, yes, because we have keenly walked the distance with them, and there are many aspects of the original draft that we've had to talk about, and some completely change, some remove, just simply to make sure that at the end of the day, the laws of the land are aligned with. And so, I mean, when you talk about the financial analysis, that's one of the funny issues that a lot of debate between the sponsors, the coalition, and thinking through what will happen by the time they get to the floor. So it is not as if this was not anticipated. So there's no surprise here at all. And I'm as confident as some George is that we'll get through this, because this is what Ghana needs to move forward.
Adam Senanu, thank you very much. He is with the Advocacy for Christ Ghana. Where do you stand on this? 055 1111 997. Ghana Connect starts in a minute.